Hey, good morning, everyone in business law. I thought I'd put up some quick videos today, one of them being Chapter 14 on personal property. The book reads well, but some of you have asked, hey, where are the videos? So um, I might as well put this up because I think it does help a little bit maybe for some of you to learn some of the information through auditory presentation. Sorry about that. Chapter 14, I think, is fairly straightforward. It talks about personal property. What is personal property? It's anything that is not really real estate. Um, Personal property, there's two different kinds. There's tangible and intangible. Tangible, the one is the easiest to talk about. You know, my coffee cup that says I love my dog, or home is where your dog is. You know, my phone, the book, this computer I'm speaking to, all of these things, my glasses, my shirt, ring on my finger. All of these things are personal property. They're tangible. They're things that we can feel. They're concrete in the sense that they, um, are dimensional. What distinguishes that in real estate is not just land, but some things on land are so permanently affixed or adapted to the land that they're not easily moved. They tend to become basically part of the land through, we call it annexation. Things like homes, large garages. And then there's a debate about how big and how permanent was the intention of the party who put it there as to whether or not it's become what we call a fixture. Sometimes you'll see like people have like a statue at the end of their driveway, like a line or something like that. Is that really part of the real estate now? Well, if it weighs 250 pounds, which I know that sounds like a lot to some people, but two people can move it in the back of a pickup truck, and maybe it has the person's name on the bottom where the front of the line is, like, Smith or Jones or Corman. Obviously, if I put my name on it, there's some intent that it probably would go with me if I was going to sell the real estate. How do we avoid these controversies, whether something's real estate or personal property, is we outline it in the contract to be safe. Sometimes like a refrigerator is built into the wall and it has the same material on its door to match the rest of the cabinetry, so it kind of is invisible. And there's a strong argument there that was the design was to be permanently in place there. And other people would say, well, a refrigerator can be relatively easily moved, therefore it's just personal property, not a fixture, not real estate. This isn't a real estate class, so I segued into it a little bit too deep. But what are we talking about this class? Personal property, tangible, movable items other than real estate. And the other is intangible. What's intangible? If I come up with a copyright of a play or a book or music, and all of those things can be copyrighted. Those concepts may actually just be in my mind. I come up with a song and I sing it and I know it, but I own that through creation, through a copyright mechanism. It's nice if you register your copyright, but it doesn't have to be protected. You just have to prove you're the one that created the concept. Trademark is somewhat similar. We covered that, I think it was in chapter 3. Trademark and service mark. If you have like a logo for your company that makes a certain good, like I always think of Rolex. Rolex has that symbol. It looks a little bit like a crown. You can imagine if I was a watchmaker, boy, would I love to use that kind of trademark for my goods because it brings goodwill. But what does it do to the actual owner of the trademark? It waters down and dilutes their ability to do what many of you are business majors, the thing called branding. You want to be able to hold on to that. You don't want other people to use your symbol. It's all back in chapter 3 but you can sell those symbols, and that's why we care. That's why it's called property. You can sell these intellectual property rights. And the other is patent. Patent is pretty important. There's a whole, it's mostly federal law. There's a patent office in almost every state, and you have to come up with a novel working either mechanism or process that's unique and serves some kind of purpose. Oftentimes you might think your concept is very original, but it might not be at all. And that's why you have to do what's known as a trademark rundown to see if there are any patents that are original to it. And sometimes you find that there's a patent for a product that's really good, but no one's ever developed the product, and you might want to buy that patent right from somebody else. So that's why they're all transferable. They all can be sold and bought. So tangible and intangible, this is what we're talking about. The ways to get it, purchase, you buy it. Will, somebody writes a will, leaves you something. I'm not going to get into this. One of the classes of the month that gets offered from time to time is estate planning. I teach wills. Generally speaking, it has to be in writing. It can't be a video will. And it usually has to be witnessed by 2 independent people and signed by the testator while competent. And competency is presumed in law, just like it is in contracts. It's presumed also in writing a will. And they can leave the things to whoever they want. You usually can't divest your spouse completely of the entire estate. So if I died and I wrote a will and I left everything to my kids, but I left my wife out of it, my wife has a right to take an elective share. We don't want people to leave spouses destitute or impoverished uh, through the ending of a marriage through death. But wills are pretty simple. Most people panic if they don't have a will. I don't even have a will, and I'm a lawyer and I write wills. I have written wills. I'm writing a few now for some friends. Um, if I die right now without a will, my estate would be pretty much shared between my spouse and my four kids. But why should I have a will? Well, what if one of my kids is very wealthy and successful? Maybe I want to take some of my assets and distribute them more to the other kids who are struggling financially. It's not out of lack of love or respect. And I would probably write that in my will, that the reason why the other child is maybe only getting some symbolic things is because the fact that they are materially well off. And the same with spouses and things like that. How much you want, and if you have stepkids, I have stepkids. Stepkids are love them just as much as my own kids. If I don't have a will, they don't technically get anything unless I have a will. So wills are important to us. Descent is what happens to most of us. We die without a will. And my point is, when you die without a will, it tends to go through. If you have a spouse, the spouse takes the first major chunk and then 50% of the rest. And often the major chunk usually takes up most modest estates. But if there's a fairly significant estate, the first 50% goes to the spouse, then the rest is split between the spouse and children. Um, and then what if there is no spouse and kids? Well, then you find out there are other parents and grandparents, and there's a whole chart in terms of descent. I think there's a ridiculous movie made by I think it's Adam Sandler. It's a remake of a movie from the 40s. I think it's called Mr. Deeds. I think he inherits something from some great uncle that he never met. That's possible. Most of us have relatives somewhere along the line that we can track down. Very few of our estates will actually go to the government because they can't track down a beneficiary of some kind. Gift. Well, 3 elements of a gift, if you want to know. It's that time of the year, right? For some of you, you want to get engaged. And usually, traditionally, one person gives an engagement ring to the other. That's the question is that a gift or is it a conditional gift that the person has a right to get the engagement ring back if the marriage doesn't go forward? I've actually dealt with a few lawsuits over that in small claims. Gift is the intent of the donor, the one giving it. If I intend to give you this pen and I have the requisite intent, I really want to do it, and I deliver it to you or one of your agents or at your home and I give it to you and you accept, those are the 3 elements: intent, delivery, and acceptance. If those 3 things happen, you are now the owner of that. I can't say, I changed my mind, I want it back. You can say that, but you have no legal right. I'd have no legal right to do it. It's not going to come up too much in business. It comes up a lot in broken relationships. And the question is, well, if I gave my girlfriend an engagement ring on Christmas Eve, that's arguably a gift because it seems like it's related to a special event like a birthday or a thing like that. But what if I proposed to my fiance at a time where it wasn't related to any season or holiday of gift giving, and it was a ring that was my great grandmother, and it's been passed down through generations in my family? There's an argument there that it's a conditional gift, that if the marriage doesn't actually become successful, the parties get married, that I might be able to ask for that back because it wasn't a completed gift. There was a condition attached to it. People sometimes are curious about extension, confusion. I'm not going to test on that. Creation, we already talked about creation through copyright and trademark and patent. Pretty straightforward stuff in the book. Lost and abandoned property. Everyone seems to want to talk about this. Lost property is always owned by the person who misplaced it. It's common sense. If I take off my wedding ring and I lose it somewhere and you find it, I have every right to get that back from you. The difficulty comes when people lose things like cash. How do you prove it's your cash? But absent that, if you can prove you're the owner of the lost goods, you still are the owner. The possessor, the person that found it, as long as it wasn't through theft, has every right to possess it until the true owner comes forward. It's called what we call voidable title. But what if the person who found it did everything? Sometimes there's actually a statute in many jurisdictions. If you advertise for a certain period of time, maybe leave the article either at the town hall or with the police department, and so much time goes by and no one comes forward and claims it and proves it's theirs, you get to right to own it. But it's always technically still subject to the true owner coming forward. So say now I own this necklace I found at the park. I go through that process. No one comes and claims it. But now I sell it to a third party. If I do that in good faith and the third party buys it in good faith, the true owner can't come forward and claim it from that person because they bought it in with voidable title. The voidable title now comes binding to the victim. The victim of the lost property is going to become just that, a victim. They won't be able to reclaim it. Um, what's abandoned property? This comes up once in a while. It came up in a Richard Nixon case, believe it or not. Richard Nixon, our former president, would throw things away. And I think he lived out in San Clemente, California for a while. And people would rummage through his trash to see, if there was letters there, mail related to something like kind of souvenir to find something out. What's he thinking doing or whatever. And he tried to argue that that was a larceny because people were stealing his trash. But when you take trash and you put it to the curb, you show your intent to abandon, and therefore it's free for anybody to come and get it. And that often is the debate, whether you've really abandoned something or not, and it's up to the intent of the owner. And you look at the outlying circumstances. If you drag something to the corner of the curb and it's trash day, I think there's a very strong argument that for all intents and purposes, those things are abandoned. That's the difference between loss and abandon. It doesn't come up. What really comes up in this chapter is the next stuff, bailments. There's three major kinds of bailments. Then there's a classification within. Bailment sounds terrible because it's like another legal term that makes you think of criminal law. Is it going to be bail on a defendant? That's not what we're talking about. We're talking about someone owning property and allowing somebody else to use it. There are three different kinds. So this is a stapler, right? My stapler. Say we're sharing, you're across the hall, you're an accountant, and you're saying, hey, Corbin, I can't find my stapler numbers. Can I use yours? I'm like, sure, you come and get it. That's a type of bailment. I'm the bailor. Owner is the bailor. That's an easy way to remember it. The bailee is the one that's going to use it. I give it to you. You go and use it. What we care about now is there any duty of care that you should owe to me for the care in case this gets damaged, destroyed, or stolen? And the test is, do I get any benefit by allowing you to use my stapler? Someone say, well, yeah, it'd be nice. Well, no, I'm talking about in terms of, they say, yeah, you can use it for the day for $1. Well, now I'm getting a monetary exchange. But generally speaking, when somebody borrows somebody else's goods, machinery, things like that, and there's no benefit flowing back to the bailor, they owe me a very high degree of care. They're almost an insurer. They won't be liable for acts of third parties, provided they use it for which I said, yeah, you can use it in your office, but don't take it home. What if they took it home that night? I say it's a Friday night, and they took it home, and their home got robbed over the weekend, and they were very careful about the way they treated the stapler. They even put it in the safe, but the safe even got stolen. They lost my stapler. Are they liable for the loss? They took great care. They took great care, but they violated the terms of the bailment. When they violate the terms of the bailment, no matter how careful they were, even if it got struck by lightning, they would be responsible for replacing the monetary value of this because they breached the terms of the bailment. I think I give a test question related to that. Now, what instead of this? What if I couldn't make the thing work? Okay, there's a problem with my stapler. Person comes in next door and says, Jim, can I use a stapler? I goes, well, I only got this one, but I can't. I got some stuck staples in it. And they say, I'll tell you what, Jim, I'm a staple guru. I'll take the thing apart. I'll get those stuck staples out. I'll make it work, and I'll bring it back to you tomorrow working. Now, are we both getting a benefit? Is the bailor getting a benefit? Yeah, my stapler's going to be fixed. Are they getting a benefit? Yeah, they're going to use my stapler throughout the rest of the day. That's called a mutual benefit bailment. What degree of care do they owe? In most bailments are mutual benefit. If I leave my car at the garage, I'm going to pay the mechanic to repair it. I'm going to get a repaired car. They get money, I get a repaired car. Benefit is flowing back and forth. Most bailments that we think of in the business world are probably going to be mutual benefit. And use your common sense. What degree of care should somebody owe me while they're possessing my goods? In a mutual benefit situation, reasonable care, consistent with negligence. They just can't act negligent. And if something happens because of their negligence, they're going to be liable for the damage or loss to the goods or the property. The next one is sole benefit to me, the bailor. I give you the staple. You're not going to use it. You're not going to get any benefit from it. But I just know you're the guru in the office that knows how to fix staplers. And I say, hey, Tom, would you take my stapler and you fix it for me? Sure. I'm not going to pay him for anything at all. He's going to do it out of goodwill. He is the bailee. He's possessing my item. But because he gains no benefit from it, what degree of care should he owe me? Slight. He'll only be responsible if he acts with what we call gross negligence or intentional conduct against a stapler. So let's assume he leaves it on the edge of his desk. He accidentally trips. He spills coffee all over it. The thing gets rusty. Is he liable? I would say no, because that was mere negligence. It wasn't gross negligence. What would gross negligence be? I don't know. He's purposely putting it right on the edge of the fish tank and letting it dangle to see if every time that maybe our boiler comes on, the building shakes a little, see if it falls in. He's kind of playing, I don't know, daredevil with my my stapler. That might be gross negligence. Or he's seeing if he can light it on fire with sterno gel and then see if he can put it out before it gets destroyed. I don't know. Really, someone's got to be intentional conduct before they're going to be liable. Those are the three kinds of bailments we have. Bailments come up all the time. I was thinking about this. I rented a backhoe once. I don't know if you know what a backhoe is. It was kind of a tractor with a big hook in it. It was putting a foundation on a cottage I was building. And I was so nervous with things because I never operated. It was a pretty big machine. And all I could think about was, this is a bailment situation. It's mutual benefit. I had to pay $350 a day to use the thing, plus a delivery fee and all these other fees. Very expensive. But it was mutual. So all I had to do was what? Exercise reasonable care. But here's the important thing about all these rules. Can you write up a contract that changes the liabilities? Yes. So what if in the contract they say, I am responsible for any damages to the hydraulics, the tracks, or anything, regardless of fault? Would I be? Yes. That would change the common law or the UCC principles that we have over bailment. So contract always rules. But a lot of times there is a contract. There was in that case, and they said I'd be liable for all kinds of stuff. And I can always remember I was using it for the first day. I was probably 6 hours in, and one of the hydraulic hoses broke. And it was pretty well worn. And they came out and they were good about it. And they gave me an extra free day, and they fixed the machine, and they didn't charge me anything. But I think there might have been an argument there that could have been trouble because it looked like I had signed an agreement to basically become an insurer for the goods if anything bad happened while I used it. I think it might have been on the hook. But it turned out that they were a very honorable company. But be careful. Contracts rules. So don't get so hooked up onto these principles, because most of the time when you're dealing with anything where you're going to be either lending or borrowing things, there's probably going to be a written contract trying to protect the owner of the goods. And you're going to be if you're the user of the goods, you also want the contract to protect your potential interests, that you're not going to be liable for any defect in the product, or if anything happens through natural wear and tear, you shouldn't be liable. And these are all negotiable terms, and you can put them in. The returned property should be in the same condition you got it in, unless the bailment was for the very purpose of changing it. So if I leave my car at a repair shop, I expect to get my car back as it was. But if they were supposed to put 4 new tires on it and change the windshield wipers, obviously it's not going to come back in the exact same condition it left, or it shouldn't. Now, there's other kinds of these so-called, special bailments. I think they come in here. I hope they do. Yeah, special mutual benefits. And this is pawn and a pledge. You should know what those are. Consignment should be in here too. I don't know if it comes up in the next chapter, but a consignment is a situation where, say, I don't like to have tag sales because I don't want to really talk to the public. I tend to be very introverted, but I got some stuff I want to sell. I don't want to put it on Craigslist or anything like that. My neighbor's going to have this huge sale. We live on pretty busy streets, so it's going to be great. He's going to do a lot of business there. What if I'm friendly with my neighbor? Can I say, hey, Tom, I want to bring over some of the stuff I want to sell, and here's the prices I want. And if you can get something close to that, and I'll give him some parameters for how much to sell my goods, I'll give you 10%. And he says, sure. That's a bailment. It's a mutual benefit bailment, but we call it a consignment. He doesn't have title, but what does he have? The power to confer title. Very few bailments allow the bailee to confer title. That's one of them where it's actually overtly allowed at consignment. The other one is a pawn and a pledge. One is for physical goods. The other is for securities like stocks. Very few people do pawning anymore, even though it's on all these TV shows. A pawn is, I just want to get a loan from somebody, but they want security in something. So, I don't know if I can pawn my iPhone for anything, but I got a coin collection. Maybe my button collection's got some value. Maybe that goofy Tiffany lamp thing. I bring it in and I say, I want a $500 loan. I want to pledge or pawn, because it's a physical item, I want to pawn this lamp. And usually what those terms are is, I'll give you $500. You have to pay us back the $500 plus interest. We're going to hold on to that lamp for a period of time. And if you don't come back with, guess what? You agree to transfer title in the contract for the term. Most people, when they go into those pawn shops, I don't know why, when I was a kid, I hung around pawn shops a lot when I grew up in Springfield, and I had some interest in actually opening one once with my brother, because we always thought there were some great deals. And people that tend to go into pawn shops are what? Usually desperate for money. So instead of pawning, you say, I'll buy the thing outright, and I'll give you basically really crappy money, because we usually sense these people are desperate, terribly unethical. And in hindsight, as I got older, I thought how wrong it was. But we used to hang around the pawn shops. We saw people come in, selling coins at really steep discounts. Usually people that have desperate financial situations. But the other one, another book does talk about conversion of bailed property. The unauthorized sale of it. They look like they have the power to sell. So if the bailee does not sell, and it goes on and says, the purpose of bail to have the property sold is fine. But if the bailor, meaning me, I'm the one that left my lamp with a friend of mine, but I told everyone that my friend of mine owns it, they could convert title because it's called estoppel. Because I made it look like maybe I'm going through a divorce or bankruptcy and I don't want anybody to know that I actually own this lamp. So I drop it off over my friend's house and there's a party there. He goes, oh, this is Tom's lamp. I was using it for a while. I'm bringing it back to him. Now Tom goes to sell it to one of those people at the party a week later. Tom would be able to convert good title because I've made Tom look like he actually owned it, and I'd be a stop from denying it because the third party is innocent and the third party has reasonable belief that Tom actually has the ability to convey title. Kind of esoteric. That's pretty much it for chapter 14. I think chapter 14 is one of the better written chapters in the book. Pretty straightforward. And then I'll put up something for 15 in a little bit. Thanks.